Hello, how are y'all today? For those of you who new, my name is Dave Sanders. I am General Counsel for the Greater Las Vegas Association of Realtors. I've been practicing law in Nevada for 17 years. Prior to coming to the association, I represented clients like Freddie Mac, Fannie Mae, JP Morgan Chase, Bank of America, the FDIC, Wells Fargo in real estate related litigation all throughout the state, including up through the Nevada Supreme Court and the Ninth Circuit Court of Appeals. My father was a Air Force officer. I was born in Kansas, and when my last name is Sanders, when my dad got promoted to Lieutenant Colonel, we went to Kentucky Fried Chicken, and he wrote a check. And since I can't cook, I had to become a lawyer. So today we're going to talk primarily about the forms that are related to the purchase agreement. We spent the morning talking about the RPA, and again, for those of you who are new, if there's time, I'm more than happy to stick around afterwards and kind of do another review of that with you. So if you recall, we went through this morning and we talked about different forms that were going to be out there. So we're going to just circle back and loop up on all of those, and then we'll do some Q&A, and if there's time, we'll stick around and go through the RPA from the very beginning. If you have questions, feel free to raise your hand. I'm more than happy to answer them. And so let's go ahead and get started. So the first thing we're going to talk about, if you recall, in the RPA, it talks about earnest money. This is an ancillary form if you get the situation where the client walks into your office and gives you the earnest money. The reason why we used to have it as a part of our purchase agreement, the reason we spun it off as a standalone form was, one, most people are wiring the funds in, so that's not as an issue. But second, the bigger reason was we had an agent in Las Vegas whose internal compliance requirement required him, this is what he made the argument before the division, was that his compliance department made him sign the section that he'd received funds. And the division severely sanctioned him for making representations that he received earnest money. And I like to joke that I'm the realtor's attorney. I want to make sure that I keep you guys out of trouble. So if the division was going to come down on a form, so we decided to spin it off. So you only need to use this if I walk into your office with a brown paper bag full of non-sequential 20s and say, here's my earnest money. So you're going to identify that you acknowledged it, date, party, what it is, cash, cashier's check, and then who it's identified to, and then the offer date, and then you're going to go ahead and you're going to deposit it. Again, highly specialized. Don't think you're going to need to use this on a regular basis, but if it is, it's under earnest money receipt. If it's going to title, if it's being wired in, you don't need to worry about this. If the client is personally delivering the funds, you don't need to worry about this. This is only in that situation where I come to your office with money. Okay? Next, we're going to talk about the contingent upon sale addendum. So if you recall, there's a section in the RPA that talks about that, and so can we go back real quick, Kendra? So just so that you don't freak out when you saw like 9 different addendums, which we're going to talk about, that's a formatting thing in Transaction Desk. It's the same form, but what Transaction Desk does, because it imports all of the data, if we don't identify different addendums, it will overwrite your existing one. So that's why they're numbered out there, so don't freak out over that. So the contingent upon sale addendum, again, it's where my purchase of if I'm the buyer, it's the situation where my purchase of the new home is based upon the sale of my existing. And so if you are familiar with other states and other jurisdictions, you're going to see a very familiar form. Any questions on the receipt? Again, the only reason why we have it is that unique situation if you have there we go. All right, contingent upon sale form. So if you are, now I will be honest, if you ever come to Las Vegas and come to my office, I have copies of every purchase agreement that's in use west of the Mississippi, so feel free, I will proudly show off my collection. I also look at every other state's forms because I am not above stealing something that's pretty good. So if you are familiar, if you practice other states, this one's gonna look pretty familiar. So you got a purchase agreement referenced, executed between the buyer and the seller, the date, the identification of the real property, and this is the language about out the contingent, my house that has to sell before I can buy the new one. So we identify the property. The first question you're going to have is if it's not in escrow, then you're going to tell me if it's not yet listed for sale. If it is listed for sale, I'm going to identify the brokerage and the MLS and the MLS number. We typically, in our market in Southern Nevada, we get a lot of people moving from all over the country, so we want to make sure to be able to identify where that is. We have the time for opening into escrow within X number of days. Once it opens escrow, I have a certain number of time by which to turn all those documents over to the seller. So if my existing home goes into escrow, I have 5, 10, 15, whatever number you come up with, to send that to the seller to proof that the property's gone into escrow. The next subsection is if it's already in escrow, escrow holder, number, proposed closing date. If it's in escrow, here's the language here, and then you have notice of cancellation. So if my property, as the buyer falls out, I have a certain period of time to tell the seller in the new transaction that it is dropped out of escrow. Seller's right to cancel. I can cancel this if the buyer fails to provide evidence that the property is in escrow, or if the buyer gives notice pursuant to this section that it's fallen out of escrow. Buyer's right to cancel is buyer can cancel at any time prior to the removal of the contingency for sale. Or if the buyer's property gives notice of intent to cancel escrow and they're unable to secure a buyer. Now, if the seller accepts a bona fide third-party offer, they have the opportunity to turn that over to, and this gets kind of confusing. So if the seller accepts a bona fide offer from a third party prior to the buyer's delivery of notice of acceptance of the offer on the sale of the buyer's property, seller shall give buyer written notice of that fact. Within 3 calendar days of receipt of that notice, buyer will either waive the contingency of the sale and closing of the buyer's other property, or seller may cancel the agreement in writing. In order to be effective, the waiver of contingency must be accompanied by reasonable evidence that funds needed to close escrow will be available, and buyer's ability to obtain financing is not contingent upon the sale and or close of the other property. Right here, notice of cancellation. Buyer is in property, is in or enters escrow. Buyer shall give written notice if either party to that escrow gives notice of intent to cancel.
Like within 2 days of the event?
It didn't. When I looked around across the country, they didn't really have a specific time frame. It's going to be a reasonable amount of time. If it's 35 days, I think that's going to be a problem. If that situation pops in, I would tell you to get it over as quickly as possible. We didn't provide a specific time frame. I think it's going to be a reasonableness factor. Could be certified mail. 3 to 5 business days, I would probably say is acceptable. But we don't have a specific, and it'll also be market driven depending on where you're at. Within 3 days, I either have to waive the contingency to sell my property or cancel the deal. Now again, you could always amend this if you want to, but we went with this. That's what they wanted to go with as a quick turnaround. So, okay. So the first thing you'll notice, request for repair number. So if you're going to have multiple requests back and forth, that's where you'd identify that. First part, we talk about the standard language about the agreement, and then the buyer notifies the seller of the following response and request for repairs. They approve the home inspection and remove it, or they request the following repairs. Now, please note we indicated by Nevada licensed contractor, again, because in Southern Nevada, the Nevada Contractors Board is extremely aggressive, not only with people who use non-licensed contractors, but people who recommend use. So we threw that in there as a way to protect you if you ever have to run afoul of the Contractors Board, because they are nasty. Buyer reserves the right to approve the repairs through the walkthrough as set forth in the purchase agreement, and buyer acknowledges that this receipt for repair does not absolve the buyer of any obligations under the residential purchase agreement. So you've got some blank space there where you would type in whatever repairs they would want to request, and if there are reports that you're going to be referencing, you would identify those there, and then the buyer signs it. And the next page is the seller's response. So they either agree to correct everything, they decline it, or they make a counter offer back. Now, we talked about this really early this morning, but does the seller have any obligation to respond to this? No, I don't. You can't make me. It's not illegal for me to not respond. And if you make a request for repair and you're in that due diligence period, silence is your answer if it comes really close to your due date, okay? So silence can be your answer. So here's the responses that the seller would indicate here. Let's scroll down. And then buyer's response, they either accept it, they reject it, or they attach another request for repair in response to whatever the seller proposed. Then we also have a separate section where the seller responds to request for the extension of the due diligence period. If you want to ask for that as a part of the repairs, you can do that. So there's a hypothetical where the seller could counter back to the repair request, but approve extending the due diligence period. So we left it blank so that you could number them and counter back and forth. I would probably identify them clearly because the lawyer in me likes to have that, so if I have to litigate over this, it's clear from the documents what the sequential order is. But that's a best practices. I'm sure you could, go with Roman numerals if you really wanted to. Well, if you wanted to do that, I think you could identify it here in this language. You would say these are the following, these are the only repairs that the buyer is requesting, and identify them right there. Well, the first one is if there are no repairs to make, so I just mark it off and say, we're good, let's move forward. The second one is I reviewed it, but I want you to do these things for me. You could certainly, if you wanted to have another inspection, you could make that a condition. When we drafted the forms, the idea was to have the walkthrough be the place where they do that review because the contract says that. You could ask for that if you really wanted to.
Okay, thank you.
Sure. And depending on the severity of the repairs, you may be able to. If it's relatively minor things, you could address it at the walkthrough. It's going to be fact specific depending on what actually needs to be done. The seller could, for example, the buyer probably would either ask, well, the following repairs were the X amount of money. The seller could counter back with, I don't want to do the repairs, but here's $500, whatever it is. You could certainly do that. And as long as the parties agree, you could sign that. Well, handymans have a license. Under Nevada state law, there's a handyman license.
Contractor's license?
It's a contractor's license to the Nevada Contractors Board. There's a handyman license that's issued by. You're right, they all do. The idea was to protect and limit your liability because you're recommending that they use licensed contractors. If the seller decides, forget it, I'm going to hire my cousin Louie to go ahead and do the repairs, you've told them in writing that's a bad idea, and that's enough to protect you if the contractors board comes through. So in Clark County, depending on the code, depending on what it is, yes or no. It's a very unclear situation with Clark County code, which is why we went with this. There are some certain things that a homeowner can do, but at least in Clark County, it's far more narrow than most people believe, but there is some things that they can do. As long as the parties agree, relative home maintenance, that kind of thing, you could probably do. If the reason why we go with the language that it's all repairs except for general home maintenance are to be done by a licensed contractor was to try to narrow that down. The problem is there's some, and then unfortunately it's all municipal code. So, for example, just in Southern Nevada, there's 6 different codes that are there, just like there is up here. So you're going to be looking at your individual. Like Incline Village, Reno, Sparks, they would all have different municipal codes, and that's where that language of what's required. So that's why we went with this to be as broad as possible. The remainder of the contingencies are identified in the purchase agreement as if they don't object to them, they're deemed to be waived. So the way that the purchase agreement says, for example, the appraisal contingency, the loan contingency, if the buyer doesn't cancel within that time frame, they've waived the right, which is also what California does in a few other states. So it's a lot more burden upon the buyer to be proactive rather than having a separate form. It's deemed to have been waived unless you are proactive. Utah's like that, California's like that. Yep. All right, property walkthrough. So address, date, pursuant to the terms of the purchase agreement, buyer is entitled to a walkthrough of the property prior to close of escrow to ensure the property and all major systems, appliances, heating, cooling, plumbing, and electrical systems and mechanical fixtures are as stated in the seller's real property disclosure statement, and that the property improvements are in the same general condition as when the purchase agreement was executed by seller and buyer. To facilitate buyer's walkthrough, seller is responsible for keeping all necessary utilities on. If any systems cannot be checked by buyer on walkthrough due to non-access or no utilities, then buyer reserves the right to hold the seller responsible responsible for defects which could not be detected on walkthrough because of a lack of such access or utilities. The purpose of the walkthrough is to confirm A, the property is being maintained, B, repairs if any have been completed as agreed, and C, sellers complied with seller's other obligations. If buyer elects not to conduct a walkthrough inspection prior to close of escrow, then all systems, items, and aspects of the property are deemed satisfactory, and the buyer releases seller's liability for costs of any repair that would have been reasonably been identified by a walkthrough inspection, except as otherwise provided by law. The undersigned agree to hold broker and agents harmless for all liability, claims, damages, demands, or costs arising from the purchase agreement or condition of the property. We wanted to include some language in here that you, as the agents, are not responsible for the seller's failure or lack of maintaining the property or conducting the repairs as agreed. So we go down. Now, so the authorized representative, so we kind of went back and forth with this. Technically a buyer, we have a lot of out-of-state buyers, as I'm sure you guys do too. And they say, I want to have somebody come out and do the walkthrough. Now you could do it if you really wanted to. I can give you a laundry list as to why I think it's a bad idea for the agents to do walkthroughs on behalf of their clients. Liability, you name it, but you could possibly do it if you really wanted to. Was that they identified this person, and then this is, so unless otherwise noted below, the property is acceptable except for the following. So this is where you would mark down anything that was problematic, that wasn't done, or whatever. Number 2 is where you are, the following items are to be checked. We weren't able to check them for whatever reason, so we identify those. If you could scroll down for me, please. And then 3, see attached supplemental escrow instructions regarding funds held or not applicable. We have a form that we have a supplemental escrow instructions form, for example, to hold the differential funds for repairs or whatever. We also know title companies have their own, so we're really generic here as to what form you either want to use, the one that the association provides or whatever your title reps use. And then we included this one again to remind the parties that it is not a good idea to waive the walkthrough. Broker recommends that buyer conduct a property walkthrough. If buyer does not do so, buyer is acting against the advice of the broker, and then they either acknowledge receipt or they waive it. We've seen a lot of litigation over walkthroughs in Southern Nevada, so this was designed to try to put as much protection as possible in place so you would avoid that if there's an issue. So, all right. Not nearly as many questions as this morning. So you're either in a food coma, desperate to get out, or I'm far more persuasive in the afternoon. I haven't decided which. So, all right, we're ready for the next one. Or you're saving them up at the very end. That could be it too. So let's talk about the addendum to the purchase agreement. Addendum, you identify one, buyer, seller, and you put whatever language you need to be in here. I do need to tell you when you're drafting addendums that contract law pretty much across the country has the following provision, that errors in drafting are interpreted against the draftor. I'm going to say that again. Errors in drafting are interpreted against the draftor. So if you make a mistake, it's going to be interpreted against your client's interests, okay? They actually punish you if you make a mistake. I'm not suggesting that you shouldn't get creative. I'm just make sure that you understand that when you're doing an addendum and you write something, you just mean to make sure that it's accurate and correct. Any questions on this? Though there's a variety of them in the transaction desk. You want to number them for the software purposes so the document doesn't get overwritten, and that's really the extent of my transaction desk knowledge. So the last form we're going to talk about, and we are zipping right through this, so there'll be plenty of time. If anybody missed this morning, you want to stick around, we'll go over the RPA again. This form here, Notice of Cancellation of Purchase Agreement, is it sad that this single page form consists of like 2.5 years of my life trying to convince this thing to get done? So for years in Southern Nevada, we didn't have an actual cancellation form. But what we did is we reached out to, we have title reps on our forms committee. We reached out to title, we reached out to mortgage, and we tried to figure out a way to address what happens when things go south. So purchase agreement, buyer, seller, cancellation of contract and escrow. So buyer, seller, or both cancel. First section would be as permitted by the good faith exercise of paragraph, so you'll identify the specific section of the purchase agreement you're canceling under, 2B, 2C, 7D, whichever it is. Per mutual agreement, the parties who just decide they're going to cancel, or other. So the next line would allow you to, a separate line item to cancel the escrow. So we're canceling the contract, we have a separate line to cancel the escrow. And then we deal with release of earnest money. And at the end of the day, there's only four things that happen when you cancel a contract when it comes to earnest money. Buyer gets it all, seller gets it all, they split it at some amount, or a judge tells you who gets it, right? Those are the options. So that's what you have. So seller agrees to give the buyer the funds, buyer agrees to give the seller. Other is where you identify a split. And the third one is hold it until we both agree or a judge tells you, judicial decision, okay? So what it does is it allows you to cancel the contract, it allows you to cancel escrow, and then it allows you to address with earnest money. And then the last paragraph here, this is the lawyer language. Unless otherwise specified, buyer and seller release each other from all obligations to buy, sell, or exchange the property pursuant to the agreement. Buyer and seller further release each other from all claims, demands, and actions the buyer and seller may have against each other by reason of this agreement. The parties intend that all rights and obligations arising from the agreement are null and void. Single page, sign to cancel the agreement. So how you would handle that is you would actually go up, you would pick number 3. Because you're going to know by the time you're canceling the agreement if the buyer and the seller are willing to split the earnest money or who's going to get it. That's probably already come up. And so if there's a dispute over that, number 3 is your option. We're canceling the agreement, but we're telling the escrow holder to hold the funds while we fight it out or we come to a mutual agreement. So number 3 would be your answer. So the best way to do that is if I got that and my seller client did not agree that the buyer's entitled to it, I'd send this back as a separate form with number 3 and say you need to sign this one so we can count. We'll agree to cancel the contract, we'll agree to close escrow, but we disagree with the disposition of the earnest money. Okay? Yeah, assuming that the parties agreed to mediate, the resolution of the earnest money would first go to mediation before it would go to small claims justice or district court. The contract is the language that you would have for the mediation. This is just telling the title company whether to release the funds or hold them. The obligation to mediate or to start that would be through the purchase agreement. Okay? Because, for example, you could have the situation where I'm a grumpy seller and I refuse to sign that document at all. You would still have the rights to mediate whether or not I signed the cancellation of the agreement. Typically, when you put the language in a transaction desk and you have a large amount of names, it just reduces the font size. So what we do internally before we let these go live, we write them, and then we have a closed beta testing inside Transaction Desk with a handful of people. And we pick folks who are high-tech people, folks who don't know what a computer is, a lot of transactions new to the business, and we send them out for about 45 days to intentionally try to break the forms with the merging and things like that with spacing. All right. Well, thank you for coming and spending the day with me. Those of you who just got here this afternoon, we'll take a quick 10-minute break and we'll jump back into the RPA this afternoon.
Good.